I have a scenario that happened last year in Staten Island, and I want to share it and then follow up just to ask if this would be covered under this legislation. Have an active duty police officer. His child went to a school in the district. His child had some issues. She was getting picked on at school. She went ahead and said that she was going to bring a gun to school and shoot them. Now, he's an active duty police officer. Under this bill, what I understand is, even though you mentioned it before, the access part is what I'm concerned about. Because even if he has it locked up in his house, there's still, even though it's in a case, there's still access because it's in the house, whether she can break into it or whatever. Under this legislation, he would most likely fit the criteria for the extreme removal, right? The extreme circumstances, because of it would only require probable cause that she would commit that act. And probable cause, as a police officer making an arrest on the street, it's not that far to get to probable cause when you're going up the chain of levels.
Is this an admission?
Say again?
It's a joke. It's a joke. Go ahead.
Wow. Okay. So, I get it. Thank you. So would, in that circumstance, he be subjected to his firearms being removed? He'd be placed on modified duty. He probably would not get his firearms back from the NYPD for at least a year, only because they would not want to take the chance legally in case there was some issue. Would that case rise to this level, do you think?
So here's first of all, probable cause is just temporary for that temporary restraining order, right? And within 3 days, 3 to 6 days, you have to have a hearing, okay? So first of all, the issue would order against the daughter. The order would issue against the daughter,
Yep.
Not the father. And so the father, under the statute, would be required to safely store his weapon. And in fact, that would be good practice for any.
Well, absolutely,
right?
I agree.
Friends of mine who are police officers, they store their guns safely because they have children and they're concerned and they're acting responsibly. And that's all this order this statute would require of someone who had a member of their household that was in fact at danger of using that weapon. So the issue would be, how are they going to, in fact, safely store that weapon? Of course, we're concerned that a kid might get into a locked case or a locked cabinet, and perhaps that cabinet isn't one that is got glass in the front, so that we're not worried about someone breaking in, for example.
Okay.
So this is a very real concern, but this bill is drafted very narrowly to ensure that no one's Second Amendment rights, no one's rights to their weapon are infringed upon, and that their weapons are not removed if, in fact, they are not the person who is in danger of acting as a threat of harm to others, and that if, in these particular circumstances where very often someone in the household gets a hold of a weapon, this happens every day in this country, that a kid gets a hold of a weapon because the parent hasn't safely stored it. And there's no reason that the parent has acted irresponsibly in any other way. This happens every day. We're seeking to ensure that those who we can demonstrate are a danger to themselves and others do not have access to that weapon.
So who would make the determination if it was properly secured? Because the application could come from the school administrator, right, who's saying that there's a threat that was made, and now we know that the student's father is a police officer. Now, who at that point is going to make that determination that the firearm is securely safeguarded, and the student doesn't have access.
Well, that is already in the penal code. And so, for example, there is a definition of safe storage depository, meaning a safe or other secure container, which, when locked, is incapable of being opened without the key, combination, or other locking mechanism, and is capable of preventing an unauthorized person from obtaining access to and possession of the weapon contained therein. So that would be, if your container met that requirement, you would not have to demonstrate anything else. So if the court tells you that you must safely store your weapon, this is what they mean.
Okay, so how are they getting into the house to inspect to make sure that it's safely secured? Is there a requirement? Would you agree that they would need a search warrant now
Yes.
to come in and make sure that the firearm is secure?
Yes.
Okay, so we're going to just take firearms without, if it's in the house, we're going to come in without a search warrant
No,
because
the
we're going
court
to
would
remove
issue
it.
that warrant. In the first instance, the court would be issuing a warrant, right?
Oh.
And so, for example, if those weapons were safely stored, the person who comes to execute on the warrant would know that, and they would know the definition of safe storage.
The warrant that you're describing is the removal warrant, or is it a search warrant? Because when they
I'm
need
sorry,
two,
it depends
they-
on what the court issues. If
So-
the court is issuing a temporary restraining order, okay?
Okay.
A temporary protective order, to remove those weapons, that would be in the court's order. That is the job of the judge.
So would they be applying for a search warrant then too? That's
The court might issue such a search warrant, yes,
okay. Right.
because that might be needed.
Okay.
And if it turns out that the lawful owner is able to safely store them, the court will return them.
We'll return the firearms.
Of course.
But you just said that they were removed because you're saying they
No,
would return them.
but it's temporary. This is not like, nobody's taking your guns forever. This is if there's a temporary order of protection, within 3 to 6 days, there will be a hearing. If you can demonstrate you have the ability to safely store that weapon and you are a legal owner of that weapon, and the court is concerned that your child is suicidal or your child has expressed to people that they want to take your gun and shoot someone, then the court would tell you, lock that up. Safely store it in accordance with the law.
But before it gets to that point where you're going to the court to plead your case, your guns have already been removed.
And then they will be returned under this law.
But that's what I'm trying to get at. At the time that they're coming to remove it, if I have it safely secured and I'm the officer, say,
Right. So
they would still take it?
Here's the thing. You're assuming that the first issuance of the protective order would be a removal order. That's not necessarily the case. It would depend on the evidence before the court. So if someone comes in and that hearing is 3 days later and says, Your Honor, I have XYZ, container that I bought at such and such a place, and that's where I safely store my weapons, the court may never remove the weapons. There's no requirement to remove them. There is an issuance of this that permits the removal of weapons in the cases where someone is a danger to themselves or other, demonstrably so, and they are not safely stored. If it was my weapon, they could remove it from me. If it is my sister's weapon and she's safely storing that, the court is not going to issue an order removing the weapon because you can demonstrate it's safely stored.
But pardon me for asking again. To me, that you're saying that they can demonstrate. They don't you're putting the cart before the horse because they have to demonstrate that in the 3 to 6 days.
Yes.
So it would have been removed already.
They might not have been removed already. That's what I said. It is not necessarily the case that the court would issue an order to remove the weapons in the first instance because there may already be evidence that the weapon is not in the possession of that person, but there is a concern that the person could get possession of that weapon, right?
Access, that's the point.
Exactly. It's about access.
Okay.
And so what we want to do is have people who are lawful owners of guns have access to their weapons, and we want other people who should not have those guns not to have access to those weapons.
No, I definitely get the intent, and I just want you to know dealing with it when I was in the police department and I saw legislation, and laws, how they're enacted. It's a big difference between what we see on paper here and what plays out in the street. And it just, I want to make sure that there's some realization how it's going to impact on the street. Because I can tell you right now, if I'm the patrol sergeant in New York City and that scenario, and I come in, we're getting probable cause, we're taking the weapon no matter what. Even if you have it, you know why? Because if we don't, it's coming back to bite us in the butt.
And the police department is free to make that determination for its employees. That is
I'm not even talking about employees, I'm talking about just anyone. Anyone. If I'm the patrol sergeant and I come to the scene and we're talking about this actual law, I'm taking it just to be cautious. And that's what's going to happen.
And in reality,
even if it's locked up.
The people who own the weapons are free. They have standing in the court to have those weapons returned. I can't control what the NYPD does, whether they're sitting on something and not returning something they should be returning. That's, you know.
Just a point of clarification. I can tell you firsthand, what we do in these chambers actually demonstrates what the cops on the street do. And I mean that with all due respect, because that's what I'm looking at. I'm looking at how this is going to turnkey from here, our votes, to what happens every day on the street. And that's the only reason why I'm asking these questions. So thank you so much.
Thank you.
I appreciate it.
Thank you, sir.